You know what is scary? It is not death. It is what happens after. When families start whispering, who gets what? I have seen this so many times. A small flat, some jewelry or savings that were meant to keep a family together suddenly become the reason people stop talking to each other. And you know the irony? Most of these fights do not happen because of greed. They happen because of confusion. Someone thought the will was clear, someone else thought everything will automatically go to the children. And when no one knows the rules, emotions take over. So today let us sit down and talk practically. No legal jargon, no scary Latin words, just the truth about inheritance law in India, how it really works, how you can protect your family and how small mistakes can turn into legal nightmare. The first big myth, I made a will, I'm sorted. Let me tell you a real story. A retired teacher in Pune, Mrs. Sharma, had made a will leaving her house to her two children equally. After she passed away, the son produced the will, but the daughter said, that is fake, mom never signed it. What followed was 3 years of court cases. You know what the judge finally said? The will was not properly witnessed, it is invalid. A will is not valid just because it is written. For it to stand in court, it must be signed by the person making it and witnessed by two people who saw her sign it, preferably not the family members. A small procedural miss and your family may spend lakhs fighting over something you could have fixed with one extra signature. So if you ever make a will, remember, sign every page, have two witnesses, keep one original in a safe place, tell someone you trust where it is. Because a will no one can find is as useless as no will at all. Where there is no will, the law decides for you. Now let us say you did not make a will. Happens more often than not? Then what? The law decides how your property is divided. Under the Hindu Succession Act, for example, if a man dies without a will, his wife, son, daughter and mother all get equal share. If there is no immediate family, it moves to siblings or other relatives. Muslim, Christians and Parsi laws are different. Each has its own share system. Live-in partners, friends or even someone who took care of you in your old age get nothing unless you mention them in a will. So if you want to leave something to anyone outside your legal heirs, even if it is emotional like a gold chain, pet or saving, it must be written in a will. To claim inheritance without a will, your family will need a legal heir certificate or succession certificate depending on the property type. Banks, for instance, won't release money until they see that certificate. It sounds bureaucratic, but that is how the system prevents fraud. The hidden maze, probate, mutation and paperwork. Now let us imagine you do have a will. Your family still cannot just walk into the bank and withdraw the money. They need probate. That is a court's official stamp saying, yes, this will is genuine. Without probate, most government departments and banks won't act. It is like the will's visa to enter the real world. For movable assets like bank deposits or shares, family need a succession certificate from the civil court. For immovable assets like a house, you will also need to apply for mutation, which updates the property records to show the new owner. Even WhatsApp message, emails or videos can help in proving a will's authenticity. Courts have accepted such evidence when witnesses are unavailable. So record your intention. Even a simple video saying, this is my will, signed today in front of these witnesses, can save years of dispute later. The money side, tax and hidden cost. Here is where most people go wrong. They assume inheritance is taxable. It is not. Good news, there is no inheritance tax in India. Receiving money or property after someone's death is not counted as income under the Income Tax Act. However, when you sell that inherited property, you may face long-term capital gain. Suppose your father bought a flat in 1995 for Rs 5 lakh and now you sell it for Rs 1 crore. In the older rules, you would index the Rs 5 lakh cost adjusting for inflation and pay 20% on the gain. But as per the changes from 23rd July 2024, indexation benefit is generally removed for properties transferred on or after that date. Now for properties acquired before 23rd July 2024, you have a choice. Pay 20% tax with indexation if that gives a lower tax liability, or pay 12.5% tax without indexation. Because your property was purchased well before 23rd July 2024, you can use either method, which results in lower tax. That rule, counting your parents' holding period, can save you lakhs in tax. Most people do not even know it exists. Also remember, you will pay stamp duty and registration charges while transferring or selling inherited property. If the deceased has unpaid taxes, the income tax department can recover dues from the estate before transfer. Disputes, the real battlefield. Now let us come to the ugliest part, disputes. If there is even a hint that someone influenced the deceased or forged a will, it can go to court. You can challenge a will on 4 grounds: lack of mental capacity, undue influence, forgery or fraud, non-compliance with legal formalities. One of the most cited cases here is Jaswant Kaur vs. Amrit Kaur, where the Supreme Court said a will must appear to be free and conscious act of the person making it. And even more recently, courts have accepted handwritten wills if they meet all requirements, proving that it is the intention and authenticity that matters most, not fancy paper or legal language. But remember, court cases drain families emotionally and financially. So wherever possible, go for mediation or family settlement. It is faster, cheaper and leaves fewer scars. Many families think a verbal promise holds no weight, but the Supreme Court has accepted verbal family settlements if later confirmed in writing. What you should do today. If you want peace for your family tomorrow, do these things today. Write a simple, clear will, specify who gets what. Keep it signed and witnessed by 2 people. Store it safely and tell someone where it is. Update it every 5 years or after major life events like marriage, birth, divorce, property, purchase. For complex assets, consult a lawyer. One mistake can cost more than the consultation. And if you have inherited something, collect the death certificate and ID proof. Apply for the right certificate like legal heir or succession certificate. Approach the bank, registrar or municipal office for mutation. Keep copies and maintain one file for all estate papers. Inheritance law is not about money, it is about legacy. It is a quiet way of saying, I cared enough to plan. When you leave behind clarity, you leave behind peace. When you avoid paperwork, you leave behind problems. So before you think this does not apply to me, remember everyone owns something. A house, a bank account, or maybe just a piece of land. Plan for it, write it down and make it clear. Because tomorrow when your family opens that one envelope with your will, the last thing they should feel is confusion. If you found this video useful, do not scroll away. Hit subscribe, click that bell icon and let us make the law simple enough for everyone to understand, even at your kitchen table.